Hello and welcome. You are listening to an informed take on current events brought to you by law students and staff of Queen's University Belfast. This is LawPod.
Hi, I'm Alana Hughes and welcome to LawPod Student Focus. This is the first of our Student Focus episodes and today we're looking at study choices. Specifically, the gender imbalance in family law, which is an area of law predominantly studied by women and practiced by women. Joining us today is Brendan Devlin, a family law barrister from the Bar of Northern Ireland. And our aim is to dispel the myth that family law is only for women and that it isn't an area of law that men should either study or practice. So hello, Brendan.
Hello.
Would you like to introduce yourself to our listeners and give us a bit of background to you and your practice and your pathway to your practice and how you got to where you are now?
I was called to the bar in 1996. The majority of my practice now, probably about 90%, I would guess, is in family law, both on children order and matrimonial work, that divorce and ancillary relief work. In terms of how I got to that stage, I mean, I've been at the bar now almost 22 years. I wouldn't say that it was something I'd planned to do initially. I don't know if I had any particular preference when I started at the bar to do any particular field. And at the beginning, as is the case I think even now, young barristers will find themselves offered various types of work across the range when they're starting out, and basically you take what you can get. And I kind of, over the years, fell more and more into family work, literally just getting briefed more and more by solicitors that I worked for regularly. And as I say, it's now developed to the stage where, as I say, about 90% of my practice would be on that basis of family work. It's, as I say, I would accept, and probably wouldn't be that many male barristers doing family work, generally speaking. It would be mostly female. But as I say, it's something that I do enjoy doing, and I've certainly no regrets doing, and well paid for. I make a very, very good living out of it.
And if I said to you, family law is for women and it isn't an area of law that men should practice or men should study, what words spring to your mind then in response to that myth?
Well, first of all, before I answer that, I think that's like saying to a female barrister that criminal law is not for them. And that's a complete nonsense. I think across the board, not just with family law, you do have discrepancies like that where you've got mostly male-dominated aspects of the profession. And certainly, yes, family law would be female-dominated, but I'm not saying that's through choice. That's just the way that's the way perceptions have operated over the last number of years. I think it's a nonsense to say that it's for women only. I think it's from a male barrister's perspective starting out, it's actually very short-sighted as well, because I think when any of us start at the bar, as was in my case, I mean, I did everything. I did criminal work, I did civil work, I did family work, with no idea where I was going. And you don't know where ultimately your practice will take you. You do the work that you get. You certainly don't turn it away. And as I say, it can be as much to do with fate, where your work comes from. That was certainly my experience, and as I say, I have done very well out of it over the years. So any male student at Queen's that has that perception, I mean, I could use the cliche and say it's a very chauvinistic statement to make, but as I say, to me it just doesn't make sense to have that perception in this day and age. You just don't know where your career is going to take you at the bar,
and there's no such thing as that route is for one person and that route is for another based on their gender. No. It's absolutely absurd in 2018, and to still think that it is a case that you would look out in court and see more women than men based on a perception that area of law that the case is in is for women and not for men is ridiculous.
It is.
So in terms of, so you say you do 90% work in the family law courts. What key attributes do you feel that you have and that everybody has in the family law courts as barristers that make you good at your job?
I mean, I I suppose the qualities are the same as in any other type of law that you would do. I mean, you have to be, there's a lot more emotion arguably involved with family cases, children order cases, private law and public law. You need to be a good listener, calm, be able to speak frankly to your client, because you're dealing with a lot of emotion, and you have to take the emotion out of it. Whether the client likes it or not, you need to be there to do your job effectively. You need to be objective, and as I say, that can be actually more challenging, I think, compared to if I was representing a client in a civil action for personal injuries, because there's a lot less emotion involved there. So it's actually more challenging, I think, to be able to deal with that, and to be able to get the client to understand the advices that you're giving, and hopefully persuade the client that what you're telling them they're prepared to listen to and go through with. So, for example, private law work in particular, where you have husbands and wives, fathers and mothers arguing over children, that is very difficult work. And I find that very, very challenging at times as well, very frustrating at times, because clients just, understandably, you're dealing with their family, but sometimes you feel they're just not listening, and it's how you deal with that. And then you have to go in with a certain package of instructions and relate that to the judge, and you mightn't like what your instructions are, but you have no choice, you have to follow through with your client's instructions are. But as I say, that can be very difficult compared with even criminal work. Criminal work is a lot in that sense. It wouldn't be as difficult in terms of the emotions involved, I think. So as I say, I think that aspect doesn't apply to family work. I think you clearly don't know what family law is about. You haven't practiced it, and you don't understand it. So, as I say, to me, I think it's one of the hardest areas to practice in for that reason alone.
And I think that is part of where the myth comes from and where it stems from, in that, family law is this really emotional area of law, and women are really good at emotions and men aren't very good at emotions. And that's just not true. Emotions are, as you say, a massive part of family law because of what is at stake. Families are at stake, or families have broken apart, and families are falling apart, before people's eyes. It's probably the worst thing that's happened to them in their lives at that stage. So there's inevitably going to be emotions involved. But as you say, you need to be objective. You need to keep your objectivity. You need to remember that you're there to do a job. You're not there to look after them. You're not there to care for them in the way that the perception might have it. You're there to try and find legal solutions that are going to help them get out of this situation that they're in. So legal solutions to get out of the situation that they're in brings about obviously legal challenges. So do you feel that there is definitely a balance between emotional and legal in the work that you do, and that's all in balancing the objectiveness that you need to sort of separate yourself from the emotional issues? That's where your legal work comes in, and your legal training and your advocacy, and in dealing with the judge, in dealing with the other practitioners that are involved in the case. And can you just talk a little bit more about how the legal issues play out in court, on the ground in practical terms?
Well, for example, if you take a public law case, so a care proceedings, we all know, when you're in practice for as long as I am, we all know what the law is. We all know what the criteria is and what has to be followed. We all know, for example, if I'm appearing in the High Court, the family judge and his general approach to things, and by and large, it's usually not exactly the same people in every case that I deal with, but there's often I'm regularly against the same people. So we all know what the lay of the land is, and it's very much about the facts of the case, a particular case and the particular arguments. I think one of the questions that had been raised with me was in terms of being legally challenging. Well, that can happen. But in public law proceedings, it's more to do with the facts of a particular case. Whether a parent, whether the trust was justified in removing children from a parent, and whether the parent can do enough to get the children back. The idea of, I don't know, this perception of it being legally challenging, this idea that, in order to be a good lawyer, that case has to be legally challenging. I mean, you could say that about any case, but when you're in practice, when you're working on the ground, you're in court, across the board, if you want to get into legally challenging cases, what are you talking about a chancery action? Are you talking about? I mean, I don't quite get where people feel this is an essential quality to have in any particular type of case. I don't get that. When you're there, you're working as a barrister. You're there to earn an income. You're not a charity, you're there to earn an income. We do our best. If a legal challenge comes up or legal issue comes up, we're all ready to deal with it. Anyway, and when it does come up, I absolutely enjoy it. I had a case a couple of years ago where a very interesting procedural point came up, which ultimately ended up being dealt with by the High Court. And that's very interesting. But at the end of the day, there is still a situation to be resolved. Is the care order has to be decided upon? Is the trust going to get one, or are the children going to go back home? So, legal arguments, all very interesting. But as I say, back to the emotional argument, that has to be sorted out. What's going to happen on the ground in terms of the facts of the case? And that's where I find I'm more interested in that.
And I don't know, maybe you'll be able to tell me more, but I think, from what you're saying, it sounds like that's the case throughout the bar, not just in family law, And I suppose to relate it to something that I know is in our exams, say for every module, we've got our problem questions and then we've got our essay questions, and the problem questions are applying the facts of the problem to the law that we've learnt and we know how it works. And then the essay question is maybe a very sort of niche area of that law that is controversial or is sort of looking at reform at the minute, and there's research to be done there's scholarly work that's been done, but it's very easy to separate them both, and you can see how the problem question is applicable practically and how it's going to be of relevance. As I go to the bar, I can sort of sit in evidence and say, right, I actually know how that's going to maybe play out in court someday. If you look at a problem question to do with burden of proof, that's not the questions of, controversial issues around the burden of proof and the shift and reversal of burden of proof. You can't ever see that coming up in the middle of a trial. So, as you say, it is the case that the bread and butter issues, if you like, of applying the facts to the law are what you make your income from 90% of the time as a barrister. And then the odd time, the legal issues will come up, and they're great when they do, but they can't come up every week either, or else then the law is in disarray because it's clearly not working. If legal issues are popping up every, around
the legal
every corner.
principles are fairly well established in children order work and indeed in matrimonial, which I do as well. So, I mean, there's no major surprises. There might be some issue, as I said, developed, and one issue may come up that needs to be looked into. But I mean, I think the kind of approach you're talking about, that's the kind of approach maybe you'll get in judicial review cases or some major commercial action or something like that. There, but I mean, that's normal for those types of cases, those types of legal argument. But family law is different from that scenario. As I say, it's more to do with the facts of the case.
Which of course are different with every
case.
Single
one size
case.
does not fit all, absolutely, yeah.
That's right. And I mean, is that an aspect of your work that you enjoy? The diversity of the people that you work with and the issues that come before you? And of course there might be recurrent underlying issues or overarching issues that sort of encompass everybody and everybody's situation. But ultimately though, the circumstances are extremely individual and unique at all times. Yeah. So that obviously involves a massive amount of flexibility in your advocacy, flexibility in how you talk to and deal with clients of different walks of life, different backgrounds. People obviously always have their different issues, and I suppose that's something that you need to take into consideration at all times. Absolutely. So you never really know what you're going to get.
No, that's right.
When a brief lands on your desk, it's not on paper. It's not what it's going to be.
No.
In real life.
Yeah, and when I've met clients, and they're completely on board, and you can work with them very easily. I've had other clients who can talk and talk and talk, and you have to give them the time to talk. You have to listen to them and hear what they want to say. A case like that this week, a client had talked for quite a while, but quite a difficult case, and I think she needed to get a lot of things off her chest.
Was this in a consultation?
It was, yeah. But it's just
before court.
It's just an example of that. Just the differences that the variety you can be faced with and have to deal with. And then, as I say, if I'm doing an ancillary case one day and maybe I'm doing a children order case the next day, maybe private law or public law, or I like that variety as well, I have to say.
You're swapping from one area of the law to another area of the law and flip-flopping between the both of them. So that's, I mean, to me, as a student very interested in family law, that sounds very exciting. The diversity is something that I don't think you could get bored of, and the idea that you're going into work in the morning and you've got your paperwork, but you haven't met the person behind the paperwork, and once you do, you can always be surprised at what you find.
And it's important to build up from the first day that you meet that person. It's very important to try and build up the relationship. So there's an element of trust there well, that they have confidence in what you're going to be doing for them.
Yeah, they're massive issues that you're being trusted with. As I said before, probably the biggest thing that's ever happened to them in their lives. So I suppose just to draw our conversation to a close, it's very clear that family law is an exciting area of law, a diverse area of law to work in. It's well paid, you enjoy what you do, and you don't have any regrets about the fact that 90% of your practice is family law.
Certainly not.
And so just to, I suppose, bring us to a close, what would you say then to a second year student at the minute who's making module choices, who turns their nose up at family law as a male because they feel that it's a female's job?
Well, unless they've got some magic ball that'll guarantee them the type of work they're going to be doing when they start practicing at the bar, if they're going to go to the bar. If I was in their position, if I could go back 20 years, 25 years, and if I had the option of family law, I'd have been telling my younger self to absolutely do it. Because that we kind of had to learn with the Children Order when we started out as we went along, and if I had had a grounding, that would have been a great help. And I have to say, I would totally encourage anybody, any student, doesn't male or female, doesn't matter who, because I'm sure you'll get female students who'll say, I'm not going to do family law. But I would encourage everybody to do it, simply because, if for no other reason, you have no idea how your practice is going to develop. And as I say, unless you're guaranteed work outside of the field of family law, for the first few years when you're starting off, and those are the hardest years of your career at the bar, you will definitely be offered. You'll definitely be offered work in the family proceedings court or the domestic proceedings court. You may be offered the odd divorce. You might even be offered an ancillary relief if you're lucky, or some sort of form of other applications to do in family or matrimonial. And any bit of backup or support you can get, and that means doing a module here at Queen's, take it. So you just don't know. You just don't know how your career is going to go. And any male student listening might be saying, well, that's not for me. It might be 20 years from now, it could be exactly like me sitting and doing exclusively family work. Just has no idea.
And of course, at the junior bar, you can't really turn work down.
No.
So if you're not in any way prepared to deal with family law cases, which are inevitably going to come to your desk, then you're setting yourself up for a bit of a disaster, and that you're not going to know things that you could easily know by studying it at undergraduate level as it's offered now. Unlike whenever
you just reminded me, actually, the other thing about if you are offered work, well, there's the possibility of building up a relationship with a particular solicitor. And if you do a good job for that solicitor, well, that means an awful lot. And who knows how that relationship might develop with more work. So, as I say, that's another incentive. And as I say, you're not there as a charity. You're there to earn a living, and you have to do cases in order to do that. So you take what you can get, and good on you if you can turn around and snub your nose up at work because you say, I'm not going to do a non-molestation order. I'm not going to do this Children Order case. It's beneath me. Well, if that's your view, well, as I say, good luck. I hope if you can guarantee yourself work in other areas, that's fantastic. But I think you're totally wrong to have that perception. It's wrong. It is silly. As I say, I used the word chauvinistic earlier on, but as I said, this applies to male and female students. Everyone should be prepared to undertake that work, and because we're all capable of it, and there's no argument to say otherwise. And as I say, I would encourage everyone to seriously consider doing the module.
Thanks a million, Brendan. It's been absolutely fantastic to hear from you, and you've got me very interested in family law, and I hope listeners that listen to this will also feel the same. So thank you very, very much for your time today.
Not at all. Thanks for the invitation.
You have been listening to LawPod, an informed take on current events brought to you by the law students and staff at Queen's University Belfast. This episode was produced by Alana Hughes and Richard Somerville. Our theme music is by Colonel Chocolate and the Justice Triangle. LawPod is funded by Queen's Law School and the Queen's Annual Fund. Thanks to Brendan Devlin, our guest speaker today. You can follow us on social media. We are on Facebook and Twitter at QUB LawPod. For more information, you can visit our website, lawpod.org, to have a look in the show notes about the topics covered today. You can find us on iTunes or anywhere else that you get your podcasts. Thanks for listening. I'm Alana Hughes, and this was LawPod.